I will now introduce our speaker. Allison G. Greenberg, Esquire, focuses on employment law and commercial litigations. Ms. Greenberg frequently negotiates and litigates on behalf of clients about workplace disputes. She practices in both New York and New Jersey in state and federal courts. Ms. Greenberg typically represents employees in disputes involving compensation, discrimination, non-competition, non-solicitation, and confidentiality provisions and other workplace controversies. Ms. Greenberg received her BA from the University of Pennsylvania and her JD from Seton Hall University School of Law. I will now turn our program over to Allison. Thank you.
Thank you so much, Gwen. I'm going to share my screen because we're with it's share, so I'm going to share. Sorry,
Okay.
corny joke. It's a pleasure to be with you all this evening. And we have about half hour or so. I might breeze through some of my slides because some of it might be a little redundant. I realize you're across the country. Some of you are not based in New York. I'll be talking a bit about some laws that involve New York City and New York State. And I do want to reach your questions, get started. Thanks so much. So it's a pleasure to be here with you. And I'm going to talk about, I'm an employment lawyer, as Gwen mentioned. I focus on employee rights. I do sometimes represent employers. And I'm going to focus on laws that impact people in the workplace, particularly people. I'm just trying to fix my screen, pin my screen so I don't see everyone. Let's see. Okay. Well, it's not working. I'm going to focus on laws that impact people in the workplace, particularly people who have cancer, and that includes people who are in remission. Even if you are thankfully cancer-free, you may still have protection under some of the laws that I discussed tonight. So please keep that in mind. I'll talk a bit about the Americans with Disabilities Act, which is known as the ADA. There's the Family and Medical Leave Act, FMLA. There are state laws, county laws, city laws, municipal laws, which provide protections to people in the workplace. I'll cover some of them. There's also a federal law known as ERISA, which is an employee benefits protection statute. And it often intersects with people who have cancer, had cancer, or otherwise might be impacted by cancer. So the ADA, for those of you who don't know, it's a federal law. It applies to employers that have 15 or more employees. It protects people who have disabilities, and it also protects people who are perceived as being disabled. This could be relevant, and it comes up often when a person might not have a disability, but she's interviewing for a job. The employer perceives her as having a disability. She doesn't get hired. There could be an issue of discrimination based on the person being perceived as being disabled. The ADA has been strengthened over the years, particularly in 2008 and 2009. There were amendments that went into effect to strengthen the law, essentially to broaden the definition of disability. So the law was strengthened so that, and I'll talk a bit about the definition of disability under the ADA, but basically a person, and I'm sorry, if everyone could please mute because I hear some typing and it's, maybe the host could just mute everyone. Even if a person needs to take medication, maybe uses a hearing aid, has an ear implant, or has something else that mitigates their disability, those mitigations need to be ignored in considering whether a person has a disability. So with respect to cancer, if you're taking medication, that helps you and strengthens you. The fact that you're taking that medication has to be ignored in determining whether or not you have a disability and might be protected by the ADA. The definition of who is protected under the ADA is someone who has a physical or mental impairment substantially limiting one or more major life activities. That's a mouthful. It could be a person who has a record of such impairment. And this is relevant for a person who is in remission, is cancer-free, has not been taking medication, but has a record of cancer in her background. She still might be protected by the ADA. And so that's something that many of you here tonight might, this might be relevant to you because you're cancer-free, but you have a record of cancer. And then again, you might have protection under the ADA if you're regarded as or perceived as having an impairment, even if you don't actually have an impairment, even if you don't actually have cancer. So that's just to give you a sense of the definition of who's protected. In order to have a disability under the ADA, part of the definition is that you have this impairment on a bodily system, and that could be a mental system. It could be your lungs, it could be your kidneys, obviously, you know, any bodily system. And under the federal law, there has to be an impairment that impacts a major life activity. A major life activity includes, and I have a list here, caring for oneself, performing manual tasks, basically all basic aspects of life, seeing, hearing, eating, sleeping, and so forth. So cancer is a disability, and people who have cancer or are in remission may have protection under the ADA. Another aspect of the ADA and the concept of disability discrimination is this concept of reasonable accommodation. It's very important because an employer is generally required to provide a reasonable accommodation when there's a known disability of a qualified applicant. So it could be someone who's not yet working for the company, but they're a qualified job applicant, or an employee, as long as it does not impose an undue hardship on the operation of the employer's business. And I'll talk a bit about what that means. As long as I can find the next slide, here we go. So a reasonable accommodation doesn't have a specific definition. As you know, people who are here tonight, you have different types of cancer, you have different grades, stages, people are taking different types of medications, your cancer affects you differently. So a reasonable accommodation that you might need to work is going to be based on your specific situation. Examples of reasonable accommodations include a leave of absence. That could be for months, it could be for days, depending on why you need that accommodation, whether it's for surgery, for chemo, or something else relating to cancer. You might need breaks during the day. You might need a shortened work day or a shortened week. You might need a place in the office, if you're working in the office, to lie down and rest. You might need help lifting things in the office. Whatever you do in your job that does not cause an undue hardship to the employer is a reasonable accommodation, essentially, under the ADA. And it's worth pointing out that each of you may have questions and may have situations. Everything is really fact specific based on your situation. So I'm giving you very general points tonight. How do you request a reasonable accommodation? You have to consider, what do you need help with? Do you need time off because you're going to be recovering from surgery? Do you need time to rest during the day because you feel very drained from your chemo? Whatever it might be, think about, is this something that my physician could help me work out in terms of articulating what I need help with? Am I seeing a therapist who might be able to help me articulate what type of accommodation is needed maybe it's not a matter of seeking a reasonable accommodation through a physician. Maybe it's something you can articulate, but whatever it is, you want to be as specific as possible. You want to put it in writing. You want to have a record of it. You want to make a record that you made this request to your employer. Generally, it's a good idea, if you can, to get a letter, at least one letter from a physician. Maybe they're more medical providers, maybe a mental health provider, whatever the situation is. Getting letters from physicians is a good way to go, because that's most likely going to have the most strength with the employer. When we talk about the employer, it's a good idea to, in determining who do you make the request to, look to see, does your employer offer an employee handbook? Is there something in paper? Is there a portal? Is there something on a computer that tells you what your rights are as an employee and what your obligations are, and how to make a request for a reasonable accommodation? Because you want to look at that, maybe discuss it with a family member or someone else that might be a support, to assess, what do I need to do to make this request? But certainly talk to your physician, be specific, and put it in writing. You don't necessarily have to ask your supervisor. You don't even necessarily want to mention it to your supervisor. Generally, you want to go to HR. You want to keep it private as you can. And if you're not getting a response, or you're not getting a good response, or you get a bad response, you probably want to seek advice from an attorney, or if not from a private attorney, from the City Bar Association Cancer Advocacy Project, which is how I'm here tonight. And we'll have contact information in the final slide. But you have other resources. You have SHARE. You maybe have someone in your church or synagogue or mosque. So you'll think about the people who can provide support and guidance to you in thinking about how to make the request and how to deal with the response. Should you tell your employer about your disability? Putting aside the question of the reasonable accommodation issue, people always often struggle with whether they should tell their employer that they have cancer or that they're going through treatment. And the conventional wisdom is, don't tell, keep it private, because you may end up giving information to your employer that could, unfortunately, make things harder for you in the workplace. So that's the conventional wisdom. I think it's really a matter of your sense of your landscape at this employer. Who are you working with? Who are you reporting to? How are you treated? Are you very supported? Is it a very supportive environment? Is it going to be extremely difficult for you to not share that you're going through a serious health issue? Is that going to create more stress for you? But you shouldn't share your personal health information if you're doing it to seek compassion from the workplace, if you're doing it because you think you need to be fair to your boss, if you think you need to owe them an explanation. Those are not reasons why you should share that information. You should only do it if you know, or you're likely, you believe it's going to help you. Someone with cancer can be fired. You might be going through treatment. You might need a reasonable accommodation. Your employer can still terminate your employment. And it may seem obvious, but you still need to perform well. Even if you need a reasonable accommodation, you're still going to be evaluated if your employer evaluates performance. And it might be obvious, but having cancer is not a blanket protection from termination. So from a practical standpoint, it's important that you are strategic about whether you share information with your employer, how much you share, whether you share information with your coworkers. You shouldn't do it to be open. And I keep mentioning the word share, perhaps because of where we are tonight, but the workplace is not a place to really share so much about yourself. It's business, and it should only be done to really help you in a strategic way deal with your illness, your recovery, and your job. If you're not happy with how you're being treated, if you're frustrated, no matter how justified you might be in being upset about a lack of response or a denial of a reasonable accommodation request, you don't want to argue or quarrel with your supervisor or HR. You want to be mindful that you're not being accused of insubordination. So it's stressful enough to have cancer. When you have to deal with it in the workplace, it's more stressful. So you want to really gauge your comfort level as you approach your reasonable accommodation request. Prepare yourself that you might be upset about the reaction, and you want to handle it in a careful way and not vent or get into a tussle with your employer. Instead, if you're unhappy about how it's going, seek guidance from outside your employer. So I see that we have people here tonight who are in Queens and in other parts of New York. If you're in New York City, if you work in New York City, if your employer is based in New York City, you might have protection under what's known as the New York City Human Rights Law. This is a very protective employee law. The ADA has been strengthened over the years, but in comparing the ADA with the New York City Human Rights Law, the New York City Human Rights Law is considered very protective of employee rights. So employees and lawyers who focus on employee rights, we love the New York City Human Rights Law, particularly when it's applied the right way by judges. This is a law that doesn't only cover disability discrimination, it covers all types of discrimination, gender, race, and so on, in the workplace, in housing. So it's broad. And under this law, you might have protection if your employer has at least 4 employees. So it covers smaller employers, small businesses, and that can be an advantage to people who work for small businesses and might not have protection under the ADA. The city human rights law has a broader definition of disability. It's basically if there's an impairment on a bodily system. So it doesn't take into account this substantial limitation on a major life activity. It's very broad. And like the ADA, disability includes a person who is perceived as or regarded as having a disability, even if they don't have a disability. Under the New York City Human Rights Law, an employer is not allowed to discriminate against a person who has an actual or perceived disability. An employer must provide a reasonable accommodation unless there's an undue hardship, which I'll get to. An employer cannot discriminate based on association or relationship with someone who has an actual or perceived disability. So if you have cancer and your family member is going on a job interview and mentions that, so let's say someone's going on a job interview and mentions my wife is going through cancer treatment and we're managing, and it does take time, but we're managing. And if it seems that this person doesn't get the job because they made this disclosure, then the job applicant might have a claim for disability discrimination based on an association or relationship with someone who has an actual disability, cancer. The city law is very important and helpful to employees because in recent years, it's become more insistent on requiring what's called a cooperative dialogue when an employee has requested a reasonable accommodation, or where an employer has reason to know that a person might need a reasonable accommodation. And let's say the employee hasn't even asked for the reasonable accommodation under the city law as it's written. An employer might need to ask, do you need help with this? Do you need help lifting? You seem really drained. I know you're going through treatment. Do you need some rest periods? And an employer is going to need to engage in a dialogue that's not just a couple of emails, but generally a discussion, something that's individualized to your particular situation. This, in theory, is what an employer is required to do when the employer is covered by the New York City human rights law. And that can be helpful to people who are going through cancer treatment or recovering or in remission. So I wanted to mention that there are different types of discrimination theories. I don't want to get too into the weeds on the law because we don't have a lot of time, and I think it's going to be most helpful just to talk about what's practical to you. But keep in mind that there may be there may be policies in your employer's handbook that talk about maximum numbers of days you can take leave. And you might see this and be terrified because you might think, oh, I can only take off 10 days. That might not be a valid policy because of how it impacts people who are going through cancer. And you may have more rights based on federal law, city law, state law. So if you look at your employer's employee handbook and it might seem to limit how much time off you can take, that might not be the final answer. There may be laws that require your employer to provide greater leave to you. So under the city law, the reasonable accommodation definition is more protective of employee rights. And the thing to keep in mind is that under the city law, unlike the ADA, all accommodations requested by employees are presumed to be reasonable unless that accommodation is going to cause an undue hardship. So essentially, this means that any type of accommodation you need that can be supported by a doctor's letter or something else that's specific, it's going to be presumed reasonable unless your employer can show that this is going to be too much of a burden on them. And an undue hardship is generally a financial hardship. At times, it could also be, let's say, if there's a hardship of someone is in a wheelchair, a ramp needs to be built in the office. It might interfere with the office space. Whether or not that's an undue hardship is going to be the burden on the employer. So in theory, it gives you a sense of a good starting point when you're asking for your reasonable accommodation. But understand that the accommodation you may want might not be the accommodation you're entitled to, and you might have to be willing to and should be prepared to be willing to to adjust and to be willing to essentially negotiate with the employer about what it is they're willing to offer, so long as it's going to support what you need from the standpoint of your health situation. Under the city law, once there's been this cooperative dialogue and the employer has given its determination, the employer must put its determination, its response in writing. And that's important and could be important in case there are legal issues down the road. I'm not going to go through the details of the state law because it's very much like the city law at this point. And I really wanted to give you an overview of how the anti-discrimination laws work with respect to disability and the concept of reasonable accommodation. Something else to keep in mind is that if you complain or complain about or object to behavior that you believe is discriminatory, and if you are subsequently demoted or terminated, you might have a claim for retaliation. I'm not here to encourage any kind of claims or lawsuit. I just want to make you aware of your rights. Sometimes people have rights because they've been retaliated against when they've complained. Sometimes it might come up if they're denied a reasonable accommodation and they've complained. So these are things to think about and to seek guidance about. Shifting gears, another body of law that's very important to people who are going through cancer are leave laws. And probably most of you who are working are familiar with FMLA. FMLA will provide up to 12 weeks of unpaid job protected leave per year. And it requires that your employer maintain your group health benefits during your leave. So I know that at least one person tonight mentioned a recent diagnosis, and this may be something of relevance to you. In order to be eligible for this coverage, you must have worked for the employer for at least 12 months. And if you're an hourly employee, it's 1,250 hours over the past 12 months. The FMLA covers employers who have 50 or more employees. So if your employer is smaller than 50, has less than 50 employees, if you're working in New York State, you would still have protection under state and city laws if you're working in the city. And as you may know, New York City has paid leave. New York State has paid leave. And when thinking about these laws, you'll recognize that it's a matter of layering your different legal rights with respect to reasonable accommodation, leave. You might be eligible for short-term disability benefits. And so it's important to have a sense of what all of the rights are and talk to someone who can help you figure out a plan if HR is not helpful in terms of what you're entitled to. You can seek FMLA to care for, if it's for yourself or a close family member who has a serious health condition. And you don't need to disclose your diagnosis. There is a particular form that is usually required. It's required that you fill out the form. You need to ask HR for that form. If they don't give it to you, you can get it off the internet. You don't have to use all of your FMLA at once. And this law is important because it protects you from losing your job while you're on leave for this time period. And an employer is not allowed to retaliate against a person for taking FMLA, or an employer is not allowed to also, interfere with a person's FMLA leave. New York City, which of course includes Queens, offers paid sick leave. And the amount of leave you're entitled to depends on how many employees there are. And this is something that you can find online. The slides will be shared. And I'm happy to talk about, particular situations if I can in the time we have tonight. An employer must allow an employee to use safe and sick leave as it's accrued with no waiting period for new hires. Employees can use safe and sick leave for unexpected reasons without giving advance notice. Employers must provide employees with a written safe and sick leave policy describing the benefit and how to use it. An employer can require documentation only when employees use more than 3 workdays in a row of safe and sick leave, if the documentation requirement is explained in the employer's written policy. And these are rights under the New York City paid sick leave law. So, and I'm sorry to be moving quickly, but we're almost at 7:45 and I want to give time for questions. We're now dealing with the shift from lots of people going back to work. And if you're a New York City employee, you know that the mayor has been requiring employees to come back to work. Private employers are trying to encourage or are requiring people to come back to the office. And so people who are living with cancer have different special concerns. There's the anxiety about going to work and will I be exposed? Am I immunocompromised? What if I get COVID? B, there are other concerns for people with cancer, and perhaps it's that you've gotten comfortable and you're feeling comfortable going through treatment, working from home, knowing that you don't have to commute to your office. These are issues that are becoming more contentious because many people are vaccinated and employers are requiring people to come back. So if you are in a situation where you're being required to come back to work and you're concerned about your particular health situation, you should absolutely speak to your healthcare provider, assess whether it makes sense to make a reasonable accommodation, including a request to work remotely, perhaps not indefinitely, but working remotely maybe for 3 months with a check-in to see if your condition has improved or the risk has been reduced. These are things to discuss with your healthcare provider. And there are no clear-cut answers because we're still living with uncertainties about COVID and whether we're going to see new waves in the future and new variants. Another area of the law is ERISA. And this is important with respect to if you have a life insurance policy through work, long-term disability benefits, a pension, a special retirement plan, and you believe that your rights are being interfered with, you were terminated or you were denied paperwork relating to a benefits plan, and you think it might have something to do with the fact that you have cancer. It might even not have to be for that reason, but if your benefits are interfered with in any way, you might have a claim under ERISA, and that's something to keep in mind. So, final words of advice before I go to your questions. In dealing with cancer and the workplace, you want to try to be stoic, recognize that you might be feeling certain emotions, understandably, because of what you're going through, but you have to be mindful to not express that anger, frustration, fear in the workplace. And to the extent you're having a hard time managing work and cancer and the emotional impact, you need to seek professional advice so that you can maintain that balance. Or if you need to take leave, explore those options. You must ask for help. Don't hesitate to ask for help. You're not expected to have all the answers. You're not expected to know how to request a reasonable accommodation, how to respond, what to do if you're nervous about your employer's response. So reach out to SHARE, reach out to the City Bar Justice Center Cancer Advocacy Project. Again, that's how I'm here this evening. You may have patient advocates depending on where you're getting your treatment. And I've recognized tonight an attorney on the first slide. His name is Arnie Pedowitz. We've done this program together many times, and he's contributed to a lot of the material tonight. And Arnie's advice is don't seek help from a yes person. You want help from someone who's a thinker and who's going to be objective and be honest with you, even if you might not like the answer. So take that into account as you're seeking advice. The final page of the slides are useful links, and you'll have access to them after the program.